Hello, my name is Connor Zapponi, Operation Managers of ECHO, otherwise known as the Educational Council of Homeowners. Thank you for participating in this educational workshop, Good Governance, Meetings, and Best Practices. ECHO is a 50-year-old statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are presented on the screen. This slide was sent to all registered attendees previous to today's discussion. Please take a moment to review all the housekeeping items. Today, we have a large audience of HOA board members. We will do our best to answer your questions, but we may run out of time. All questions will be answered during the Q&A portion at the end of the webinar. To try and answer as many questions as possible, please make sure your questions are concise and to the point, and we will be using the voting feature in the Q&A to answer the most relevant questions to the most participants on today's call. Also, make sure your questions are general in nature, as questions about specific issues may not be answered by our speakers today. Please use the chat feature to report technical issues and to communicate directly with other participants in the webinar. We do not monitor the chat for questions. Now let me direct your attention to the monitor where you will find our disclaimer. None of what is said during this seminar shall be construed as specific legal or expert advice from the speakers, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you. And now I'm going to introduce our two speakers for today. Brian Campisi is the president and CEO of the Manor Association Incorporated, a leading community association management company with offices in San Mateo and Santa Cruz County. The Manor Association represents common interest developments throughout the Bay Area and Santa Cruz, with over 36 years of experience representing residential and commercial associations. Brian is a recognized leader and subject matter expert in HOA space. He has been a speaker at numerous educational events, and he has partnered with city governments and nonprofits to address municipal efforts, which include conservation and sustainability initiatives. With Brian, we have Amy Tinetti. Amy Tinetti is a shareholder with the law firm of Hughes, Gill, Cochran, and Tinetti since 2004. She has been representing homeowners associations in all aspects of their day-to-day operations, including governing document analysis, interpretation, revisions and enforcement, elections, real property and title issues, planning and collections of large special assessments, analyzing and drafting agreements with vendors, and member disputes and litigation. I want to say welcome to both Brian and Amy, and thank you for being here today. And I'll hand over the reins to you.
Thank you, Connor. I'm not sure if it was my connection or yours, but you were breaking up a little bit. If I start to break up, let me.
It looks like it may be Brian's connection.
It looks like it's yours.
Me know, and I'll see
Brian, it's yours.
about what we're doing here today. We're talking about good governance, and in the context of board meetings, we want to walk through some key issues that you should be thinking when you're running your meetings, kind of the do's and the don'ts. A lot of the material is basic in nature, but very important in terms of how you operate your community and how you operate as a board.
Hey, Brian, really quickly, can we start from the top? It looks like your connection broke up for the first part.
Okay, yeah, I think I'm having a little audio here issue, so let me see if I can fix that real fast. Well, it was working so well when we were testing it, and now I'm having a problem.
It seems to have cleared up a little bit. If you want to go ahead and start from the top.
Okay, so let's go ahead and get started with meetings generally. Let's move on to the next slide, and we'll start with meetings. So as I was saying, I think I'm up. We're going to talk about board meetings today, and in the context of the board and how they should act in a board meeting setting. Board meetings are where you do your business at the board. It's where you make decisions, and that's your job as a board, is to make decisions on behalf of the homeowners association. I always advise boards that your job is to vote. You can't always govern by consensus. Your job is to vote. Board meetings, there are certain rules surrounding board meetings. Open sessions require notice. You have to post a notice or notice your community 4 days in advance of a regular board meeting. What does that mean? I use kind of a simple little format for what that date, which is if you're meeting on a Thursday, I take that Thursday and I count backwards 5 from there, including Thursday. So if I count back, post notice on the previous preceding Sunday. That's my 4 days notice. With executive sessions, you have to post notice 2 days in advance for executive sessions. It's very important that you post your notice. We'll talk a little bit more about agendas as we move on here.
Okay, so I'm
moving
going to
the
talk.
quorum.
Oh, wait. So I'm going to talk about the Open Meeting Act and how the Open Meeting Act defines a meeting of the board. So you can see the first bullet point there is the definition in the Open Meeting Act. There's 2 kind of important parts there that I want to focus on. The first is a quorum of the board. That's going to depend on the size of your board and what the bylaws say about what a quorum of the board is. We'll talk about quorum in a little bit more depth in a second. So I'll leave that part till the next slide. The next part of this definition, though, that I want to talk about is hear, discuss, or deliberate upon any item of business that is within the authority of the board. Well, the boards of common interest developments make the vast majority of the decisions for the association. So that's actually really, really broad. Any item of business is within the authority of the board. Is almost anything that board members would be talking about that had to do with the association. Also, hear, discuss, or deliberate is very, very broad. So you don't even have to be saying anything. If you're there with other board members, you're hearing, and if it's a quorum of the board, that's sufficient to be having a meeting. So also note that the Davis-Sterling Act refers to a meeting as a teleconference. So it's the same standard. If it's a sufficient number of directors to establish a quorum, they can be in different locations, connected by electronic means, which means audio, video, or both. And then finally, meetings are not to be conducted via a series of electronic transmissions. That's been part of the Davis-Sterling Act since 2014. There's one thing I want to talk about that's not on this slide, and that's, you may have heard, and we've been getting lots of questions from board members that we work with about this case that was decided this year. That's a very weird title, so I always have to look at it. LNSU #1 LLC versus Alta Del Mar Coastal Collection Community Association. And it has to do with this last bullet point about email discussions, which we're also going to discuss later in the presentation. What that case says in a very tortured analysis is that meetings have to be in a physical location, which they don't have to be, especially after January 1, 2024. So the analysis is kind of obliviated as of January 1, 2024. But the basic premise, or the holding in that case, is that boards can discuss things via email. They just can't make decisions, and that discussions via email are not meetings. I've talked to lots of lawyers who do the same thing I do, and we all agree this is a very, very bizarre case. It's actually it's under review for depublication. I've been doing this for almost 20 years, and I can't remember a time where a case has been under review for depublication, which indicates how concerning the case is. So we can talk more about email later. I would just say for now that I would be very cautious as a board member to not discuss items of business within the authority of the board via email. Brian, you want to talk about quorum?
Yes, I apologize for taking my video down, but I'm having some unstable internet here, so I want to make sure that at least my audio is working okay. Again, let me know if it's not. Quorum. So quorum is the minimum level of participation needed to act or conduct business at a board meeting. And member votes. It's important, I think, as Amy just alluded to, it's important to really understand what a quorum is for you, and that a quorum of board members talking about homeowner business anywhere constitutes a meeting. So you could be at the pool, you could be at the post office, you can be at the grocery store. A quorum of board members talking HOA business constitutes a meeting, and unless it's properly noticed, then potentially you have them there. So it is important to understand where quorum is for your particular. In many cases, a 5-member board, 3 board members represent a quorum, but your bylaws will dictate what your quorum is. Same for membership meetings. There are quorum requirements in your documents that will provide information about membership meetings. And I think a little bit about some new code that goes into effect in January.
Yeah, so I wanted to mention 2 things. One, on the board meetings and the quorum requirements for the board to conduct business. Usually the bylaws say one of 2 things. They say either it's a majority, quorum is a majority of the authorized number of directors, meaning if you have 5 board members, a quorum is 3, regardless of how many are actually seated. Some bylaws will say a quorum is a majority of the directors then in office, meaning if for some reason you don't have a full board seated, which does happen on occasion, say you're supposed to have a board of 5, but you only have 3. If your bylaws said quorum is a majority of the directors then in office, your quorum would actually be 2 in that instance. So it's really important to look at what the bylaws say, because usually they're drafted one of those 2 ways. So in terms of changes to the civil code that impact quorum, that is in the member vote arena, and it's actually only one type of member vote. So as of January 1, 2024, for those associations that have quorum requirements more than 20% for director elections, the law, again, as of January 1, says that if that association is unable to meet that quorum requirement, let's just say for purposes of this discussion, the quorum requirement is a majority of members, and you have 100 members, so you need 51, and you can't get it. The law, again, as of January 1, 2024, will allow the association to reconvene the meeting at which ballots are opened and tabulated and a reduced quorum will apply to that meeting, and that reduced quorum will be 20%. There are some other notice requirements that apply in order to take advantage of this. The pre-ballot notice actually has to say there's a possibility that quorum could be reduced to 20%. And there's an additional notice that has to go out after the decision is made to reconvene the meeting. So this is new. Work with legal counsel. I'm actually in the process right this minute of doing this for one of my clients who has traditionally not been able to achieve quorum. Their election of directors is scheduled for February. So we're preparing this stuff now with the idea that we'll be able to take advantage of this reduced quorum provision in the law as of February, because it goes into effect on January 1st. All right, so the next topic of discussion is open meetings, which Brian already talked about a little bit. So when we talk about open meetings, what that means is they're open to the members, and the members, I've never seen a set of governing documents that don't define a member as a record owner, meaning that person's name is on the deed. That's what a record owner is. So except for things that are allowed to be discussed in executive session, which Brian's going to talk about, board meetings must be open to the members. So that's what I was talking about with that bizarre case, is that the whole idea of this and what we're talking about is that members have the right to know when directors are meeting. We're going to talk about agendas in a little bit more depth. They have the right to the agenda, so they know what the board is going to be talking about, and they have the right to attend the meeting and observe the board conducting business. So board meetings, unless it's executive session, must be open to the members. That bullet that says not open to tenants or other non-members, what that really means is that they're not legally entitled to attend. Record owners are the only ones that are legally entitled to attend, but there are plenty of associations that do allow non-members, residents to attend. Just know that they don't have a legal right to attend. Brian, do you want to talk about who should run the meeting?
Before even I want to ask you a question about an owner who wants to bring their attorney to a meeting. Is the association required to allow that?
The association is not required to allow that. I think it kind of depends on the meeting. I usually take the position that they shouldn't be allowed to attend open meetings, but if for example, an owner has been called to a hearing and they want to bring their attorney, I will say, yes, I think you should allow that. But it's something that is going to depend on the situation, what they want to discuss. And really, you should talk to legal counsel about that to make sure that it isn't a good idea to have the association's legal counsel present as well.
Okay. Should the meetings be run by the association president? Every association is different. There are hard and fast rules that say that meetings run by the association president. Some communities, the board or the board president wants to run the meeting, and they run very good meetings from start to finish, and the manager is there to support the board. In other situations, the president introduces the manager, and the expectation is the manager is going to lead the meeting from beginning to end. So, there are no hard and fast rules of how you do it, but it's something you should talk about and make sure that there's some coordination between your manager and the board or the board president in terms of how the meeting's going to be run. So with that, we can move on to the agenda. So before a board may discuss or act on any item, it must first appear on a posted agenda. So this is one of those laws that came into effect with the Open Meeting Act. and it essentially prohibits the board from taking up topics that haven't been announced to the membership. So if you're going to talk about something or you plan to talk about something in a meeting, you have to make sure that it's properly posted on the agenda and within the time limit, so 4 days before the board meeting. Typically, when a board is constructing their agenda, it's a collaborative process. The manager will normally prepare a draft agenda and send it off to the board and ask the board's input. And with that input, the manager will finalize the agenda so that it can be posted in time for the meeting or 4 days before the meeting. Sometimes we run into situations where a board has a difficult time agreeing on the agenda topics. And it doesn't happen very often, but when it does happen, we typically say that, you know, you should adopt a policy in terms of how, which spells out how you're going to set the agenda. That policy may include things like, you know, the manager will submit a draft agenda to the board president, who will then solicit input from directors, and the board president will have the final say on what goes on the agenda. In other cases, it can go so far as, you know, we'll vote on what's put on agenda. Typically, you know, our stance is should be heard if it's something that they want. On the agenda, because next we're going to talk a little bit about open meetings and items not on the agenda.
Okay, so if I know Brian's still having some audio issues, so I apologize if there's things you aren't getting, put them in the Q&A and we'll try to adjust those. I think what Brian was saying about the agenda and setting a policy is it's going to be very dependent on the association and what makes sense. And again, it doesn't come up very often. Most of the time I never hear about agendas, but sometimes there are issues and it may be appropriate, for example, for the board to decide, okay, we're going to require that 2 directors have to agree to put something on the agenda, because then, you know, you have a first and a second for that particular item. So we can discuss that more if people have questions afterwards. So in terms of what to do when an item is not on the agenda. So just going back to the basics of the agenda, it does have to be posted before the meeting, at least 4 days before an open meeting. And the board is not allowed to take action on an item that's not on the agenda. So assuming it's not on, something comes up that's not on the agenda, what can you do? You can briefly respond to statements or questions from members, and those usually come up in homeowner forum, which we're going to talk about in just a second. You can ask questions. Can you give me more information about that issue? Whatever that is. You can make brief announcements if you'd like. You can make brief reports on activities. Oh, we already plan to have the arborist out to look at all the trees in the community on X date. That's fine. You can refer information or tasks to the manager, even if it's not on the agenda. So again, these are issues that almost always come up in homeowner forum, and it is perfectly appropriate to say, manager, can you have the landscaper look at that issue when they come out next? Can you have the arborist look at that tree and see if there is in fact a problem? Emergencies. If something is, some action is needed on a matter that arose after the agenda was distributed, you can talk about that in the meeting, but I've never seen an issue where if it's a true emergency and it comes up between the time that the agenda was posted and the meeting, you're dealing with it before the meeting, if it's a true emergency. So it's very rare that the emergency comes up at the meeting, and that's when you're having to deal with it. But technically, if there was a true emergency that came up at a meeting, the board could deal with it then. And then if an item was on a recent agenda and it was continued to the current meeting, those items can be discussed. All right, I'm on the next slide. So hopefully by the time, it looks like Brian's still working on stuff. So member participation. So this is what I was mentioning, is that most of the issues that come up, I mean, obviously, we don't know what's going to come up at homeowner forum. And as I mentioned, members are allowed to attend, homeowners are allowed to attend, and they have the right under the law, the Davis-Sterling Act, to address the board at any open session board meeting, meaning any open board meeting must include a homeowner forum portion. Doesn't say when it has to be. Some boards do it at the very beginning. Some boards do it at the very end. I've never seen boards do it in the middle, but you could if you wanted to. And an important thing to note is that the law says that the board shall establish time limits. Very common to have, 3 to 5 minutes per comment. I've also seen boards that say we're going to take 20 minutes for homeowner forum. And if there's 10 people who want to address the board, they each get 2 minutes. So it's a little uncomfortable sometimes, but do know that the board is not only allowed, but is supposed to establish time limits for homeowner forum. And I'm going to assume that the reason for that is these are business meetings. This is when the board is to conduct business. So the entire meeting should not be homeowner forum. And as I mentioned, the board is not obligated to respond or address the homeowner. And as I said, they're actually legally prohibited from doing that by the by the Davis-Sterling Act, because that says the board can't act on an item that was not on the agenda. So it's perfectly appropriate to say during homeowner forum, thank you for bringing this to our attention. We will ask the manager to investigate further. We will take this under advisement and address it at a future meeting. Whatever, there's a few appropriate responses, but I've seen a lot of boards feel a lot of pressure during homeowner forum to respond. And it's perfectly acceptable to say, we can't address that issue at this time. And we're legally prohibited from doing so. All right, Brian, executive session.
Let me give it a try here. I'm so sorry. Not sure what's going on with our internet problem.
I think there's still issues, but let's give it a shot.
To keep talking and then let me know if you can't hear me. Executive session. To the members, except those members who are invited to the meeting, say perhaps for a disciplinary meeting, or a particular homeowner asked to attend a meeting strictly with the board. The board is limited in terms of what they can discuss in an executive session. So you can't just call an executive session meeting because you want to talk about a particular topic. Outside, do that. The topics limited in executive session include the formation of contracts, member discipline, personnel matters, litigation, which Amy will talk a little more about, and delinquent assessments. So those are the 6 topics that you can talk about in executive session, 5 topics that you can talk about in executive session. You can't just decide that you want something outside of an open meeting if it doesn't fall within this category. Amy, do you want to talk a little bit more about litigation?
Sure. I wanted to mention something, and then I'll talk about the litigation thing. You'll notice that that what's not on this list is conversations with Dave, to answer your question. Yes. what's not on this list is conversations with legal counsel. Those conversations between a board and the association's legal counsel are privileged and confidential. So those, even though it's not on the list, those by their very nature need to be in executive session, should be in executive session. In terms of litigation, I just want to make clear that that doesn't mean there's a lawsuit that has been filed. Litigation can be someone says, I'm going to sue the association. Someone can say, I'm going to sue the board. Someone can say, I'm going to talk to my lawyer about this. Anything that looks like it could be, you know, if it's a discrimination, someone's raised a discrimination issue, that's potential litigation. And that should be discussed in executive session. In terms of the last bullet point, because I'm not sure that that Brian was heard on that, board members are, as part of their fiduciary duty, are required to maintain confidentiality. Board members, there's a reason that these are discussed in executive session, these things. Board members are privy to information that the non-board members are not privy to. Information about, for example, their neighbor's finances, maybe their neighbor's personal life in the context of member discipline, things like that, or in the context of delinquent assessments. So there's a reason that those things are discussed in executive session, and they must be kept confidential. All right, let's talk about remote meetings. This one, I have good news for you all. I'm sure you've heard it, but as of January, so let's back up for a second. We got some emergency legislation in, I think, late 2021 that said in the state of emergency, you can meet by Zoom. So we've been doing that. Obviously, most people are very big fans. So there was an effort to say, well, why don't we just take out this emergency requirement? And that effort was successful. So as of January 1, 2024, all board meetings and member meetings may be conducted entirely by teleconference and video conference. So it was AB, meaning Assembly Bill 648. It amends Civil Code Section 4090 and adds a new Civil Code section which is 4926, about remote meetings. So a lot of the stuff that was in the emergency legislation is in this new law as well. So those include the notice of the meeting must contain technical instructions and contact information to assist people with remote connections before and during the meeting. Participants have to have the option of participating by telephone. We can't assume that everyone is going to be able to get on, a Zoom meeting and appear by video conference. So you have to have the option to participate by telephone. Votes of the directors must be conducted by roll call. So I was actually in a meeting that was a remote meeting the other day, and the way they were doing the votes of the members was all in favor say aye. That's not a roll call vote. So it has to be, Joe, how do you vote? Judy, how do you vote? Amy, how do you vote? You have to go through each director and get a yay or a nay, a yes or a no, however you do it. But that's what a roll call vote is. And then the last point on this that I want to make is that a physical location is still required for meetings at which ballots are opened and tabulated. So that's secret ballot votes only. There's still some things that we can do by non-secret ballots, but for secret ballot votes, there has to be a physical location. The one thing I'll say and the law is, well, it's not clear at all on this, is whether the inspector of election has to be at that physical location. So I would say if a question comes up about that, talk to legal counsel, because as is pretty typical, the law is somewhat confusing in that regard. Okay, next we're going to talk about emergency meetings. Okay, so emergency meetings are required if you cannot possibly provide notice. So we're talking life or limb type things. It cannot be foreseen. It must require immediate attention and possible action by the board. And again, because of the necessity, it is impracticable to provide notice as required by law. So there's this asterisk here that says most situations do not qualify as an emergency under the law. So check with legal counsel before calling these meetings. I'm racking my brain trying to think if I've ever received a call where I've said, yes, that is an emergency. Most of the time it is not. And poor planning or putting something off for months because you just didn't want to deal with it doesn't make it an emergency when you have to deal with it, because that is reasonably foreseen that you're going to have to. So what I always say is when I get the call, is this an emergency? Can we have an emergency meeting? I say, what's the issue? If it's an executive session issue, which, you know, there was that list of topics that can be discussed in executive session. If it's an executive session issue, I say, can this wait 2 days? And if the answer is yes, then it's not an emergency. If it's an open session issue, I say, can it wait 4 days? And if the answer is yes, it's not an emergency. So emergency meetings are not special meetings. There is actually a category of special meetings, but it's just emergency or open that wasn't previously calendared. So just because you're having another meeting somewhere, if you meet quarterly and you decide, oh, we can't wait until next quarter, that's not necessarily an emergency. It's probably just a special meeting. And it's in, you know, whether it's an open meeting or a executive session meeting. All right, so I think I'm on for the rest. So sorry about that, people. You have to listen to me. So we're next on to meeting minutes. So I find that there's a lot of questions about meeting minutes. They are meant to be a record of the board's decisions and any items that are tabled for later discussion, but they're not a transcript of every word that was said. And they really shouldn't include those details about discussions or deliberations. They're a corporate record so that if there's a question about, I mean, we get this question all the time, were the election rules adopted? Sometimes we need to go back and look at the meeting minutes and figure out, yes, they were adopted. That's the kind of thing that needs to be in the meeting minutes, not Joe said this and then Judy got really upset and then they fought for a little bit. That's not what your meeting minutes are for. And keep in mind that the members have the right to request all open meeting minutes from the beginning of time. So it's important that they be succinct and brief and really are just a record of the board's decisions. All right, so I've already mentioned emails, but we're going to talk about them a little bit more because this actually is really important. So despite what that case says, which I'm pretty confident is going to be depublished, I would be shocked if it was not. Even if it's not, it's still a really good idea to avoid emails amongst a quorum of the board because they still can inadvertently constitute a board meeting. So how do we avoid that? Don't reply to all. I see that happen all the time. It's really easy not to do that. And if the number of directors on an email is sufficient to constitute a quorum, again, your documents will tell you what a quorum is, then a series of emails can be considered a board meeting. You can only meet by email if there's an emergency. I just mentioned what emergencies are. Let me just tell you, it's a lot easier to have meetings by like teleconference, conference call, or Zoom, whatever it is, than it is to have emergency meetings via email. And having a transcript really of your meeting is probably not the best idea for the protection of the board and the association. But if you decide for some reason you're going to have an emergency meeting via email, the reason it's kind of difficult to do is all of the directors have to consent in writing to have that it's an emergency and that you're going to meet on that emergency by email. And then you have to have those consents attached to the minutes of that meeting. Again, it's a lot easier to just have a teleconference, whether that's video, audio, or both. All right, so that's kind of in the meeting context, but there are additional risks of email. In our office, we like to call email evidence mail, because, and Connie, thank you, because it finds its way into the hands of the membership or the jury in the event of a lawsuit or a judge. And we've been in situations where those emails are read aloud in a courtroom, and it's never been positive. We all know that we tend to be more casual in email. We tend to say things in email that we wouldn't say face to face. So there are lots of reasons that email should be used sparingly. Practice tip, if you're on the board, do not use your employer's email. If there is a lawsuit, your employer is not going to be very happy if their hard drive is subpoenaed and taken so that your email can be searched for association emails. So really easy to set up a personal email exclusively for board business. And you may be saying, but Amy, you didn't tell us, you told us not to email. Look, email is a perfectly acceptable form of communication. I have hundreds of emails a day. But what email should be used for in the board context is distributing information. It's a great way to distribute information. So it's typical for board packets to be sent by email. Perhaps at a meeting, the board decided to get bids about something. Very, very easy to distribute those bids by email. The issue is when you start discussing those bids via email, because really those discussions should be probably an executive session because you're going to be talking about formation of contract with a third party. So I think I've harped enough on the risks of emails, but we can discuss more in the question session if you'd like. So we can go on to conduct and behavior at meetings. All right, so the board should, the directors should treat each other respectfully and treat the members respectfully. Unfortunately, most members don't attend meetings and attend homeowner forum and talk during homeowner forum when they're happy. Sometimes it happens, but frequently it's to address some sort of concern that they have. So they do have the right to do that, and it's important that they be heard. And that everyone, and again, it is a business meeting, so it's important that we treat everyone, that everyone is treated in a professional, business-like manner. All directors should have the opportunity to be heard, just like the members have the opportunity to be heard. All directors should vote. There used to be this idea, which I haven't heard in a long time, about the president only votes when there's a tie. I don't know where that idea came from. The right to vote comes from your director position, not from the officer position. So the president is an officer position, but directors all have the right to vote lies with the directors, and all directors should vote. And then there's no requirement in the law that directors agree all the time, and there's certainly no requirement that votes be unanimous unless you're dealing with a very small board and a very small quorum. But it's important that all directors speak with one voice. So after the decision is made, it's important that it be supported to promote respect for the way, for the fact that the decision was made the right way, even if someone doesn't agree with it. So that doesn't mean you have to go out and, scream from the rooftops how great the decision was, but it shouldn't be second guessed and it shouldn't be undermined after the decision is made. those times to have that discussion are at the meeting. And once it's said and the decision's made, it's a decision of the board and it should be supported as such. And that's it. We are on to Q&A.
Okay, we're gonna go ahead and head into the Q&A now. Just a reminder, if you want to go into the Q&A feature yourself, you can vote for your favorite questions. There's a little thumbs up icon in the bottom left-hand corner of the box that will tell us which ones you want to hear from first. And with that, I'm going to go ahead and give you the first question here, Amy and
Okay.
Brian.
Lay it on me.
What are the penalties for a violation of a meeting requirement? Example, you do a board meeting via email or something like that. You have a quorum. What are the punishments for that?
Well, there are several sections in the Davis-Sterling Act that allow members to file legal action and get, now I'm going to blank on the term, civil penalties in the amount of for some reason, $500 is always the civil penalty. So violations of the Open Meeting Act are one of those where members can go and file a lawsuit and be awarded civil penalties of $500 for every violation. So that's one issue. Another issue is that there could be a lawsuit for, I don't know, there could be a lawsuit for a violation of the governing documents, for violation of the Davis-Sterling Act, for a violation of fiduciary duty. And if those emails exist, it's going to be pretty hard for the board to say, oh no, we didn't meet by email. So that's, those are ones that come to mind.
Great, thank you. We have a question here from the Habitat for Greater SF. If HOAs want to have a private meeting to discuss HOA related issues without the board members, are they allowed to do that? And then they have a second part of that. And if they do so, do they have to notify the board that they're having the meeting?
Okay.
So it sounds like members are meeting independently in a clubhouse or something along those lines.
So there's a provision in the Corporations Code, and it's somewhere around 7511, 7512 of the Corps Code. Don't quote me on that, but in that neighborhood, that says the members can petition for a special meeting for any item of business within the authority of the members. So, but in that case, they would be, notifying, they would be submitting that petition to the board, because that's the only governing body for the association. So so going on to the next part, yes, they could have a meeting. It would be like a town hall meeting. The members just wouldn't be able to take any, legal action at that meeting. So I don't know if that answers the question, but and if notification is required for a member meeting, it's at least 10 days and not more than 90.
Okay, great.
This is like a test here.
Exactly. We're seeing how much you know. We have anonymous attendee here that has a question. What are the penalties for a violation of a meeting requirement? We already went through that one. This one is from Leslie Stewart. If you start your meeting with a quorum of 3 out of 5 board members, and one member needs to leave before the end of the meeting, do you still maintain a quorum?
Yeah, well, yes, assuming 3 satisfies your quorum requirement, which it probably does, but the 2 that are left would have to agree.
Yeah.
Otherwise, you don't have majority of quorum making the decision.
Yeah. So if it ended up one of the people who was there, then you would have 204, which does not meet that quorum. Is that correct?
Right, but I understood the scenario to be 3 down to 2.
Yeah.
And if that was the case, yeah, 3 would achieve it, and 3 is quorum, but you would need a majority of those, so that would be 2.
So that would be something you would probably put in your in your minutes or something along those lines.
Yeah, that would be a good idea, because it's not going to make sense if you've got 3 people. Usually the agenda or the minutes say, here's who's in attendance. And then if you get to the part where it says, motion second and only 2 are in favor, they're going to wonder, well, what happened to the third person?
Okay, perfect. I think that is good for that one. On to the next question from anonymous attendee. I think this is one we can answer independently. So we're going to move on to Vicky Harvey. She asked, should the treasurer report the financials at the meeting? So I'm guessing this is an open meeting.
There's no legal requirement that happen, but it's certainly pretty normal for the treasurer to give a report at the open meeting. But there's nothing in the Davis-Sterling Act that says the treasurer must provide a report at the meeting.
Okay. We have the next question from 176-449. Are approvals for landscape changes in the common areas required to be on the agenda and voted on during an open meeting? So if you wanted to make changes, add new plants, make renovations to the patios, does that need to be on the agenda in order to be voted on?
I would say yes, unless there's a new contract for that, in which case that would fit under formation of contracts with third parties. So it's probably going to be kind of dependent on the issue.
Yeah. So if it's, say you were adding completely brand new or redoing your landscaping in a certain area, that might be a good idea to put in there. But if it's just something that has to do with maintenance or something along those lines.
Yeah, I mean, the reason I brought up the contract issue is if it's not part of your landscape contract and you actually have to enter into another contract for that work, for additional work, then that would be probably handled under an executive session, because it would be formation of a contract.
Perfect. Thank you. Okay, we have a question from an anonymous attendee. My board, so the board likes to make decisions in executive session, such as hiring of vendors for a particular task, so similar to what we were just discussing. Then in open session, they announce who they have awarded the contract to. Should that discussion to hire a vendor and the actual design be made in open session? So should they be discussing that with the members before, picking a vendor in executive session?
Usually that's going to be considered formation of contracts with third parties. And that's pretty typical that the decision is made in executive session. And I can't say why, I don't know why the law reads the way it does. What I've always assumed is that it's because there's things in bids that vendors do not want disclosed to the homeowners. They may be, trade secrets, things and they don't want disclosed to their competitors either. So that's why I've always thought that those issues are discussed in executive session. It's really for the privacy of the vendors and what may be in their proposals or bids. And then it is pretty typical to say, we met in executive session, we voted to select this vendor for this work.
Perfect. Okay, we have another anonymous attendee. They say,
be anonymous. Is that possible?
Can the answers be anonymous? Let's
Yeah.
see. We can turn off your video and change your name and pretend.
I'm kidding.
We recently held our annual meeting of the membership. The management did not provide an agenda for the meeting, stating that the notice of an annual meeting of the membership was the agenda, even though the bylaws for their association require specific items to be, put on the agenda. And then also management. And the management during this member meeting did not provide an open forum session.
So
Is there a question here? Yeah.
good question. Is there a question? I guess the question is that okay?
Yeah, I will go with that. She just puts thoughts at the bottom, so I'm assuming is it okay? Does the notice of the membership meeting fill in for the agenda in that case? It looks like is the question here.
Unfortunately, well, first of all, let me just clarify that what we just talked about was really about board meetings and not member meetings. So and I probably should have mentioned that. I think it's sometimes confusing to people because they're open board meetings, and I get asked that all the time. Well, that makes it a member meeting. No, it's not a member meeting because members can attend. Member meetings are completely different from board meetings. So I just want to make that clear. And unfortunately, the answer to the question is it depends. Really, what is supposed to be on a member meeting agenda is items that the members are going to be asked to vote on at the member meeting. And it's actually pretty rare now for members to vote on things at the member meeting, because the things that and usually the only member meeting is the annual meeting, and pretty much everything that we used to vote on, everything association members used to vote on at annual meetings has to now be voted on by secret written ballot. So it's a really tough question to ask without knowing the specifics. So that's the best I can do, which is kind of the framework that that the law provides.
Okay, thank you for that. We have a question here from Barbara Robinson. If you have a teleconference meeting, how do you know who is a member or not, and how do you control that? What are some things that you've done with your clients?
That's a great question. So I've seen it done a bunch of different ways. I don't know if any of them are ideal. I've seen where usually actually it's the manager who is saying, hey, that 727 number, can you please identify who you are so I can change you? I mean, a lot of times they'll change the name either by the address or so there is that confirmation. I think it's perfectly appropriate if someone doesn't identify themselves as being a member that you don't let them attend the meeting. So I haven't seen a very efficient way to do that, but that's the way I've seen it done, is that they're asked to identify themselves by their address and their name, but sometimes the address is the best that we have in terms of information on who the members are. So sorry, that's not a great answer, but that's how I've seen it done.
What do you think about having a roster of the people who live in your community available for either the president or the manager at that time?
I think that's a great idea. I think, and I think as we meet, we've been kind of doing this Zoom thing kind of on the fly because we were forced to. So now that we're going to be able to do it, legally, I think we're going to have to implement some of those procedures so that we do know who the record owner or owners are of a particular residence. So you've got the whole list and the address, the list of members and the address.
Perfect. Thank you for that. We have a question here from an anonymous attendee in regards to an executive session. Can the HOA member require that their hearing be held in an open session? So disciplinary is where this goes, I believe.
Yes. So unfortunately, it's it depends. under the Davis-Sterling Act, the answer is yes, because the law says disciplinary action can be discussed in executive session. I think it says at the discretion of the member or something like that. But the bylaws may say that the board has the discretion to determine whether that should be discussed in executive session, even if the member wants it to be in open. So it's unfortunately, as with many of these things, it kind of depends on what your documents say.
I'm gonna take one here. That
All right.
this one is in regards to when holding board meetings via Zoom. There's kind of two parts. So Amy, maybe you can lay in on half of this. Is a physical location still required with the new law that is in January?
The answer is no, with one exception, and that's meetings where secret ballots are going to be opened and tabulated. There still has to be a physical location for those meetings.
Yep.
The question is, who has to be there? That's the issue because of the way the law is written.
Perfect. And the second half of this question is asking on phone numbers via Zoom. Can somebody call in and everything like that? Just for everyone on the call, Zoom has phone lines that are built into every single meeting, so somebody is able to call in and do all that very easily, and they don't need to go somewhere with video. They just need to be able to call in.
Yeah, and we should probably say too, this isn't an ad for Zoom. Zoom has kind of become like
the go-to.
the Kleenex of video conferencing. It's just sort of the term we use. And when we're in meetings, we just put a sticky on our door that says Zooming. So people know what it means, but we don't necessarily mean it's just Zoom. There's other video conferencing.
A majority of video conference software out there. There's Google Meet, and there's a bunch of other ones as well that are smaller. They almost all of them have a telephone number that would be into.
Absolutely. And the law requires that if you're going to meet by video conference, that people do have the right to call in. But I've met in a lot of different for a lot of different systems, and they always have phone number options.
Okay, we're going to move on to Tom's question here. Tom asks, can a board vote to add an agenda item at the beginning of a board meeting?
No, not unless it's an emergency.
Okay, nice and cut and dry for that.
Some background there. The reason that we give people notice and the agenda 4 days in advance, assuming it's a open meeting, is because in theory, people have the right to look at the agenda and go, oh, they're going to be discussing the landscaping. I want to go to that meeting. So if it's not on there, then they weren't given that option. Perfect.
Now we're going to move on to Peter's question. Peter asks, if your all-member annual meeting immediately precedes an open board meeting, do both of them need a homeowner's form? So it sounds like they schedule at the same time.
Technically, they're two different meetings, and yes.
Yep. So you'd probably have to meet the requirements for notice as well for both of those as well.
Oh, yeah. Yeah, you definitely need to meet the notice requirements. But luckily, the notice requirements for the member meeting are longer. So you're always going to meet the board meeting notice requirements if you notice it at the same time as the member meeting.
Perfect. We have a question here from an anonymous attendee. It's kind of outside of today's scope, but we'll get a little variety. Can a homeowner request for reimbursement if they have for damage caused to their unit, if they believe that the HOA was responsible for the maintenance of it?
Yes, but that is it depends. Yeah, that one's really hard to answer.
Yeah, that one's going to probably include a lot more specific information
Yes.
to answer succinctly.
Yeah, and it's actually not addressed in the David Sterling Act at all.
Really?
No.
Okay, we're gonna move on to the next question from another anonymous attendee. What's the recourse if a director's requested agenda item, provided well in advance, are consistently blocked by the president or another member of the board?
The recourse is to discuss it and say, I suggest we have I suggest we establish a policy about having about how we set agendas. But the difficulty is if it's one director and one director's agenda items, there's not a second. So that's why sometimes it makes sense in that situation. If you're having issues, the policy might be to have two directors decide to request to put something on the agenda, because then there's gonna be a motion and a second, because it's kind of a waste to just have a motion and no second every time.
Okay, thank you for that. We're gonna move on to Carol's question. She says, our minutes indicate that a motion was made, seconded, and carried. We don't indicate who voted or how many votes were yay or nay. Is it required to include that in your minutes?
It is not a requirement. It's again, the minutes are supposed to be a record of the board's decisions, and it sounds like that is happening. I mean, I've seen it many times, MSC, motion second carried. So it's kind of a personal preference of the board, whether they want to say it was, 3-2 and list names, but there's no requirement for any of that.
So just making sure you have the MSC is good enough in that case.
Well, that's a record of the decision, which is what's supposed to be in the minutes. Yeah. Beyond that, it's personal preference.
Okay, perfect. Steve asked, what is a quorum for a 3-member board? If only 2, then how can any 2 of those people have a conversation? So this is an email question.
Yep, it's difficult. Was it Steve? Yeah, it's
Yep.
I feel for the 3-member boards. It's pretty difficult because, yeah, you're absolutely right. Quorum would be 2. And if only 2 people are in attendance, they have to agree on something. It can't be 1-to-1. That's not a majority. So, and yeah, any 2 directors in that scenario, if they were emailing about items of business within the authority of the board, that would technically be a board meeting that wasn't noticed, which could be, is a problem under the Open Meeting Act.
Okay. We have another question here from an anonymous attendee. Is every director able to bring forth agenda items, assuming they're provided well in advance and that they haven't previously been addressed at a meeting and were documented in the minutes? So this sounds.
It's kind of like that previous question.
Yes.
The answer is all the law requires is that there be an agenda. There's nothing in the law about how the agenda gets set. If there's an issue with how the agenda is being set, then that needs to be discussed and decided upon by the board if there's an issue with that.
In regards to that, Amy, is there have you had any clients that have made like an agenda policy that they adhere to?
Yeah.
And that's how they do it, and it doesn't pertain to they don't have issues creating their agendas at that point?
No, actually, I mean, again, in my experience, it's been pretty rare, but I have had boards do that, and I will say I haven't heard a whole lot about it after the policy was adopted, so it seems to be working.
Anonymous attendee asks, is having a miscellaneous agenda item listed for a board meeting appropriate?
Miscellaneous for a board meeting?
So on the agenda, they have miscellaneous as one of their agenda items. Is that
tells people what you're going to be discussing. So I'm not sure that that's going to be sufficient in terms of the notice and agenda requirements.
In this case, miscellaneous could be, you know, stuff from other meetings or in that case, but
Well-
then why not just put that as your agenda item?
Exactly. Exactly.
Okay. Beth asks if 3 of 5 members is a quorum, 4 are present and 2 abstain from a vote. Do 2 voting members affirm a motion carried? So it sounds like they have 4 people, but 2 don't want to vote and 2 do vote.
No, because that's not a majority. A majority in that case would be 3.
Al asks, can a person who resides with an owner but is not on the deed attend the board meeting?
The answer is legally they don't have a legal right to attend, the person who's not a record owner, but the board could decide yes, that person can attend. And I think the vast majority of the associations I work with, I don't think they prohibit residents from attending, non-record owner residents from attending. The issue sometimes becomes, though, when the non-record owner becomes very disruptive in meetings, and then it's very difficult to say, oh, that person can't attend, but all the other non-members can attend. So it's usually it's not an issue until it's an issue, as with many of these things we're talking about.
We have another question here from Steve. He asks, in light of the reply all ruling, how do we operate as a 3-member board if a quorum is only 2? Can 2 people even email each other about HOA business?
I think we addressed that one, but I do want to comment. I love the reply all ruling. There is no such ruling unless you want to call it the Tonetti rule, which I'm happy with. But no, there's no law that says thou shalt not reply all. Yeah. I wish there was, because it can be very annoying when you get when you're on an email with 50 people and everyone replies to all. But no, there's no such ruling. It's just a practice pointer that it's not a great idea. And yeah, if you've got 3 people, if you've got a 3-member board and you've got 2 or 3 on the email string, then you run the risk of having a meeting that hasn't been noticed.
Yep. We have another question here from Habitat in Greater SF. They asked, do you recommend recording your board meetings? One of our HOA property manager records all board meetings. Is that allowed, or is it a good idea?
Allowed, the answer is only if everyone has consented to be recorded, because California is a dual consent state. So everyone has to consent to being recorded. I personally don't think recording board meetings is a good idea. Because again, the record of the meeting is supposed to be the minutes, and that's really only supposed to reflect the decisions of the board. So I have had people ask, can we record them for the sole purpose of preparing the minutes, and then we'll destroy them? And I think that's again, you have to deal with the consent issue. But assuming you want to do that, I think having a meeting policy or a meeting conduct policy where that's explained is a good idea, so that people aren't asking for the recordings.
Yeah, and just to follow up on the question a little bit here, if you do end up recording a board meeting and you get into litigation, is that whole recording available?
Potentially, yes.
So, be careful when you're doing that, because there may be some things that were said that don't reflect what you wrote in your minutes either.
Well, yeah, it's usually not. It's just not a good idea.
Okay, we have another question here from an anonymous attendee. Is posting the agenda in the management email portal okay? Or is it required to physically post it somewhere?
The answer is the law requires that what am I trying to say? The location for posting general notices has to be included in the annual policy statement. So if that is a website address or a website, that's fine. As long as it is identified in the annual policy statement.
So it could say all of our agendas are put on XYZ site. That's where you can view them. That's fine.
Yeah.
Okay, it looks like
And
Brian
Brian's
has
gonna
a.
try to- It looks like Brian's gonna try to hop in here
Yep.
on occasion.
I see that.
Yeah,
I'm gonna give you the toughest question now.
okay. I'm hoping that my audio is more stable. I've been typing away in the Q&A, trying to answer as many questions as possible. And again, I apologize for
Oh,
the
well, thank you for doing that.
audio issues. So
You still have audio issues.
I did want to comment on the question because sometimes, still bad, huh?
Yeah, but go ahead.
Sometimes we will record a meeting only for the purposes of drafting the minutes, and then we'll delete the recording.
Right,
So
and
we'll
that's
do
what I
that for
said.
some-
I think that's okay, but out of an abundance of caution, I would like there to be a policy for that association that says this is what we're gonna do.
Exactly.
We have another question here from 176-449. If a contract has been approved and the board has concerns about how it is being executed, can that then be discussed in executive session?
Well, if the thought is that you might terminate that contract, then I think the answer is yes. I mean,
I agree.
I've always interpreted formation to also include unformation or deformation.
The opposite.
Yes.
Okay, perfect. Nice and easy
Especially
there.
because if you don't do it right, it could lead to litigation. So I think it kind of can be it can be covered under both of those categories.
Okay, we have a question here from Rick. He asks if the board is required to produce minutes of the executive session.
The answer is no. Open meeting minutes are available to the members. Executive meeting minutes are not.
And kind of in that same vein, would the board make minutes for themselves? Just
The law requires
distribute.
that there be minutes of every board meeting, and executive sessions are board meetings.
Yep.
So there must be minutes, and then the law requires that anything discussed in executive session must be generally noted in the minutes of the next open board meeting. So there has to be, the board met in executive session and
Discuss
approved
contracts.
a contract, with this person or something like that. Or took disciplinary action against 10 owner or whatever it is. But you're not giving addresses, you're not doing things like that. But the one exception is that sometimes in a lawsuit, the executive session minutes could be subpoenaed and could be subject to discovery.
So the board is required to produce them and then just generally note them during an open meeting.
You're not required to produce them except
Yeah.
as, in part of unless ordered to as part of a lawsuit.
Yeah.
But you do have to keep them. They have to exist.
Okay, we have a question here from an anonymous attendee. If the board insists on having discussions or taking decisions via email, despite the opposition of another board member, what should that board member do? I think we're gonna need a little bit more information for that one specifically.
Okay, do we want to try another?
Yeah, let's go ahead and move on to the next one. This one is from Susan. Susan asks, during an open meeting, are your members allowed to insist for an answer to a question?
Absolutely not.
That was a softball one there. We have another question from an anonymous attendee. What should a director do if the rest of the board insists on having discussions via email?
So I'm guessing this person is on the board and the rest of the board members
Are emailing and
are emailing.
Mhm.
Well, if you've got an attorney that you work with, I would certainly get the attorney involved and explain the risk to the board members. That's what I would hope would happen with my clients.
Okay.
Because then if the attorney advises against it and it still goes on, then they're at risk for not being protected under the law or the insurance policy.
Well, here's a question for me from Francis. Francis asks if they will get a copy of the responses to the Q&A. Yes, you will. It is part of the recording of the webinar. So if you want to go
super.
back, you can go and listen to them nice and slow. If you want a response to the written answers that Brian and Dave are doing in the background, you will need to email me for that. We have a question here from Rick. How does a member best challenge a board abusing the executive session requirement to make decisions without membership consent or knowledge?
Well, that one's really difficult because there's. Can you read that one again? Because there was something in there I wanted to specifically comment on. I'm sorry.
How does a member best challenge a board abusing the executive session requirement to make decisions without membership consent or knowledge?
So the membership consent was what I wanted to hit on. There's very, very few things that the members consent on. There's a handful of things that the members get to vote on. Sometimes that's by secret ballot. Sometimes there's actually other ways to vote depending on what the issue is. So the consent issue, that doesn't really come into play. And in terms of knowledge, if it's something that can be discussed in executive session, again, there's a reason that that's discussed in executive session, and then it has to be generally noted in the minutes of the next meeting. So I don't know. It sounds like something where there might be some specifics that I don't have and probably can't give you legal advice on, but that's the general answer.
Okay, we have a question here from Bonnie. What do you do if the attorney only communicates orally with the board president and not with other members of the board? Or only orally and only to the board president?
Well, I would say sometimes that's another one that's really difficult, because sometimes it's not unusual for a board to decide that the president, or sometimes we have another person who's like the liaison to legal, that has been authorized by the board to do that as the conduit. Because the difficulty for us is we don't always know who's on the board. So it's helpful for us if we kind of know who we can talk to, and we take our direction from the board. So if that's the setup, that's the setup. But you can certainly discuss with the board, hey, I'm not comfortable with this. I'd like to do it another way. I'd like, the attorney's opinions to be shared with everyone, and the board can make a decision to do something different. But again, it's really hard to answer because kind of every board has a different way of going about how they engage with legal. But we, like in our office, if we get a call and someone says, I'm from ABC Homeowners Association, I don't talk to that person until I know if that person is on the board and authorized to talk to me, because I do bill for my time, and that's two reasons. I bill for my time, so I don't want to bill the association if I'm not authorized to do something. And second is, the attorney-client privilege only extends to the board. So anything I say to a homeowner is not going to be privileged, and I really can't give a homeowner non-board member legal advice. So it's kind of a complicated one. And I would discuss your concerns with the board, and if necessary, legal counsel.
Okay, thank you for that. Steve Rubin asks, is the board required to approve the minutes of an executive session?
Well, it's kind of an interesting question because the law says that within 30 days of the meeting, there have to be minutes, but they can be in draft. So in theory, you could have draft minutes that have never been approved, but are still quote unquote legal. So yes, they should be approved, but there could certainly be a situation where they're not. But they have to be around after 30 days. But again, executive session meeting minutes aren't something that has to be provided to the members.
Okay. We have a question here from an anonymous attendee. If during an open meeting a director violates the governing documents, can a member bring that to the attention of the board?
Was the question a member or a board member violates the governing
This one looks like a normal member, so a member of the residents.
So there's a violation during a meeting? That was the question?
Yeah, so if during an open meeting a director violates the governing
a
documents.
Director violates.
Yeah.
Okay, violates the governing documents during a meeting.
Mm-hmm.
Can that be brought to the attention of? Can
a member bring it to the attention of the board?
Yes.
That they violated it?
Yes. Either in homeowner forum or, whatever your association has set up in terms of communications, most of the time it's email the manager, and then the manager will compile everything and give it to the board to review.
Okay, perfect. Here's another anonymous attendee. Does the question of whether to arrange a new board orientation with the attorney fall into an acceptable executive session item? So this sounds like talking to an attorney and getting like introductions out of the way and how that privilege will work with you and your attorney.
Yeah. So the what's throwing me off is the word arranging. I mean, if it's just, hey, let's get this thing scheduled, that can be done by email. I mean, to me, that's purely administrative.
Yeah.
And that can be done by email. If the question is, should the board training be in executive session? My answer is it should be, yes, because again, anything we say is privileged. And even though generally the idea of the board training is that we're giving general information, we may be talking about specifics that we know are going on in that association, and that should be privileged. It is privileged.
We have another question here from, it looks like Dave is going to take that one. We have a question here from another anonymous attendee. The board does not want to consult with the HOA legal counsel. Can the board member contact the legal counsel directly? So maybe the board doesn't agree, is what it sounds like. And one board member doesn't want to contact legal and the other board member does.
Yeah. Boy, these are tough questions.
We're hitting you with the hard ones.
Well, the answer, and the answer is there's not really anything in the law that says a board member has the right to contact legal counsel. But if a board, I'll just say for me, if a board member was to call and I was able to determine that that person was in fact a board member, which I'd probably have to go to the manager to ask, because again, we can go years without talking to some of our clients. So I don't know who's on the board at any given time for some of my clients. So I would probably do that, and then I probably would have a conversation with the board member, but I would want also to let the board member know, hey, I'm in a bill for my time. Is that going to be an issue? Because I'm there's not a lot of attorneys that are going to work for free for much time. My lights just went out. I'm not moving enough. I'm going to wave my arms. There we go. All right.
We have a question here from Annie, and it looks like she just missed part of your explanation on the reduced quorum requirement going into effect in January.
Okay.
If you could restate that for her.
Okay, so it only applies, let me try to do this as succinctly as possible. It only applies for director elections, number one. And it only applies for those associations that have quorum requirements for the election of directors that exceed 20%. So let's say you've got your governing documents require a majority of the members. I'll just use my 100 member association again. So a majority of 100 is 51. Let's say that's the requirement, but you can't get 51 ballots back. The law says that you can reconvene that meeting, or you're going to open and tabulate ballots, and the quorum for that would be 20%. So I don't know if that makes sense. So that would be 20 in my scenario. But keep in mind, a lot of bylaws already have a reduced quorum provision. So let's say, again, in my scenario, it starts at a majority and it drops down to 33 1/3, which is pretty common. Then the 20% would still apply. You could avoid the 33 1/3 and you go straight from a majority down to 20. But if your reduced quorum is already 20%, then this new law doesn't apply to you. Additionally, quite a few associations who have revised their governing documents in the past few years, especially when we started really dealing with huge owner apathy issues and could not achieve quorum, it's very common for kind of newer bylaws to say there's no minimum quorum requirement for the election of directors. It's just the number of ballots received by the deadline. So if your bylaws say that, obviously this doesn't apply. It's only going to apply to those associations with quorum requirements that are higher than 20%. So I hope that answers it. If not.
Yeah. Annie actually says thank you for the explanation.
Okay,
she put it in here.
I'm glad that I answered your question, Annie.
And she just wanted to know, does that need to be noticed in a specific document that they're doing that reduced quorum?
It gets noticed so it's part of the pre-ballot notice. So the pre-ballot notice, which we lovingly call the save the date notice in our office, is the notice that has to go out at least 30 days before ballots are sent. So that's where you say, we're going to have an election. Here's when ballots are going to be due. Here's where the meeting's going to be. Here's the address to return ballots. Here's the name of the candidates. Now, in addition to all those things, you need to say, basically, if quorum is not achieved, the meeting can be reconvened, and the quorum for that meeting will be 20%. So that has to be in the pre-ballot notice.
Okay, thanks for that explanation again.
Yeah, and I'll mention one other thing, because they can't do this stuff without giving us like a million different notice requirements. So there's that. And then if you decide to reconvene, so let's take again my majority, and we decide we don't get a majority, so we decide we're gonna reconvene and go with 20%. 15 days before the reconvened meeting, a notice has to go out saying, when the reconvened meeting is, again, no, and sorry, this is like brand new. I'm doing this for the first time right now. So notice of when the meeting is, the names of the candidates again, and another statement that quorum for that reconvened meeting will be 20%. So there's one additional notice if you're going to do it, and then an additional thing that must be included in the pre-ballot notice. Hope that answers. There's a lot of stuff.
Yeah. A lot of hoops. It sounds
a lot
like.
of hoops. I mean, as I've said, I think I'm very happy that I have a client that is already taking advantage of this law, knowing that it's going to be in effect. So they've got a meeting scheduled in February. They have not achieved quorum in ages. So they're already planning to take advantage of this. So we're just doing the pre-ballot notice stuff now. So I'm just learning this stuff as well. And as I've said, it's a very good idea. I'm hoping it will help a lot of associations. The execution is a little bit flawed, which is pretty typical.
Yeah. Okay. Hopefully we have another quick one here from Steve. Do the minutes have to reflect abstentions and recusals?
Do the minutes have to reflect abstentions and recusals? That's a great question. Legally, no. Again, there's very little in the Davis-Sterling Act except you have to have minutes, but nothing about what they're supposed to say. So I certainly don't think it's a bad thing, but I can't sit here and tell you that the law requires that.
It's a good idea, but not needed.
Yeah. It makes sense from a purely mathematical perspective. So you're not trying to figure out, well, wait a minute, why do we only have 3 votes for this or whatever it is? So I certainly think it makes good sense.
Perfect. We'll take a couple more questions here and then we'll go ahead and wrap it up for the day. We have a question here from Teresa. She asked, should homeowner addresses be used for identification? I'm assuming this is in regards to a teleconference. So should owner addresses be used as identification on the agenda, or should privacy be respected and some other form of either an account number or a plot number or something like that to be used?
Well, they shouldn't be on the agenda. And I think that they don't have to be. There really isn't anything that says how it has to be. I just think there needs to be some system in place for the person who's running the meeting to confirm that the person is actually a member. Or if you allow residents to attend, a resident. That doesn't mean you necessarily, I've seen it where the unit number is identified or something like that. That's not to say you have to do that. But if behind the scenes that what's the word I'm looking for? That you've confirmed that confirmation is happening and then you're identifying them in some other way, that's fine. And board members, I mean, you have to, if all the board members are appearing via video conference as well, someone has to know who to call on. So for that roll call vote, so you've got to identify them in some way. Probably by name is how you're going to do it. And you could identify the members in attendance by name also, again, as long as someone is confirming that they have the right to be there.
Okay, perfect. This will go ahead and be our last question for today. We've gone through about 75 of these guys with the help of Brian and Dave in the background, also typing some of these.
How many were? Oh, okay. So there's still 32. Wow. Okay.
Yeah, there's still 32 in here, but we've gone through almost, 75. This will be 76. And hopefully we get a softball at the end. Are all agenda items which involve the HOA attorney automatically discussed in executive session?
All HOA items which involve the HOA attorney. The answer is no. We do on occasion attend open meetings, so that wouldn't be an executive session. But what I always tell people is just know that, you know, it under very, very limited circumstances are those discussions privileged. Most of the time they're not. And it's sometimes very confusing about who we, the attorney, represents, because we don't represent the homeowners. We don't represent the board. We actually represent the association, the corporation. So that can be confusing to people. So when I attend an open meeting, I try to make it very clear who my client is.
Okay, well, thank you for
But
that,
like,
Amy.
sorry, Connor, things
ahead.
like special assessments, when we have town hall meetings, which aren't really member meetings or board meetings, but it's very, very typical for us to attend a town hall meeting about special assessments to explain the legal requirements and the legal ramifications of special assessments. So that's one example I can think of where it's not an executive session and we're absolutely in attendance at that meeting.
Okay, well, thank you for that, Amy, and for answering questions here today. You know, we've gone through almost 80 questions, so that's quite a few. I know Brian and Dave are working in the back end as well. We're helping out with answering some of those, but we're going to go ahead and continue and wrap up today's webinar. I just want to thank you to all the ECHO members for coming today and supporting the ongoing ECHO webinars that we're having. For those who are not ECHO members, please consider becoming a member and supporting HOA boards throughout the country. To join, simply head to www.echo-ca.org and click on the membership tab. For ECHO members, thank you for supporting us, and please invite your friends, boards, and especially management firms and vendors to join ECHO. A simple invitation is often all it takes to encourage someone to join. If you would like to be more involved with ECHO, we have a few opportunities for you. Please refer to the slide. If there's anything there that looks interesting to you, you can send an email to David at dzapponi@echo-ca.org, and he can help you out with sorting some of those out. Now we're going to move on to some other announcements. You know, even though our 2023 resource panels have come to an end, we will be returning with them next year in 2024. If you want to take a look at the slide, these are the first set of resource panels we will be doing in 2024. The topics are still being decided on, but you can note these dates on your calendar and come and see us at one of these local resource panels. With that, we also have the ECHO Boards Members Club returning in January. This is going to be on the 9th. The ECHO Board Members Club meets every second Tuesday of the month from 5:30 to 7. The Board Members Club meeting is open only to ECHO members who have served on their HOA board or are currently serving on the board. These meetings are highly interactive peer-to-peer learning forums. And if you want to sign up or learn more information about that, you can shoot me an email at connor@echo-ca.org, found there on the bottom of the, right there in the middle of the slide, I guess. And I can help you with getting signed up for that if that's something that interests you. Other things of note, in 2024, ECHO will be launching a new educational program focused on HOA board preparedness. The core curriculum of 10 courses is designed as high-quality training for HOA board members, interested homeowners, and professionals. If you participate in this program, you can earn a certification for HOA board member preparedness. The courses will be initially offered live, and we will also have online ones available if you happen to miss a course in this program. If you want to be more involved and sign up for this program, you can shoot me an email. My email is found there at the bottom of the screen. Also, this is our last webinar of 2023, and we want to thank you for a great year. These are our starting webinars for 2024. So we have our community conversation coming up in January. We have another good governance course. This one will be on elections, voting, and candidacy coming up on the 1st of February. Then we will be doing a board ethics workshop. That is a 2-part course on a Wednesday and a Thursday in the middle of February. And then lastly, we have our popular Ask the Attorney about the Davis-Sterling Act. It's a Davis-Sterling overview of all the chapters in notated form. So we don't go deep dive, but we do cover the major points of every part of the Davis-Sterling Act. And with that, I just want to say thank you to both Amy and Brian for participating today. And I also want to let all the people who are still on the call here that the slides and a recording of this presentation will be sent to you within 7 to 10 days of today. I want to thank all of the participants for sticking around and participating in the Q&A. And I just want to say thank you for the great year of 2023, and we look forward to seeing you in 2024.